Welcome back from our quick break. Mike and I will be co-moderating the session today, and it is my pleasure to introduce Jesse Reiblich, who is an assistant professor at the University of Rhode Island. Jesse's research interests include coastal access and related topics, including the public trust doctrine and surf break protection. Most recently, he worked on a research project studying the effectiveness of Rhode Island's shoreline access law and published a review of public access emerging issues and potential solutions. He also recently published a book chapter about how technology can protect access and has a manuscript under review studying how social and environmental data can assess coastal access vulnerability to sea level rise. Jesse approaches coastal access from a legal perspective and teams with interdisciplinary researchers to address these issues. And with that, I'll turn things over to you. Thank you so much for your time and for being here.
Thank you for having me. As Lily mentioned, I am Jesse Reiblich. I am a professor at the University of Rhode Island in the Department of Marine Affairs. And so today I'm going to be talking about assessing the effectiveness of Rhode Island's shoreline access policies in the context of climate change. And this work was funded by the National Sea Grant Law Center. All right, so now I just need to see how I can go ahead. All right, here we are. So this is Rhode Island. If you've never been here or never heard of us, or maybe heard of us but don't know where we are just south of Boston. We have Connecticut to our west, Massachusetts to our north and to our east. Pretty small island. They call us Little Rhody, smallest state in the United States. It took me actually some doing, finding some sort of like a good representation of the offshore piece of the state in addition to the state itself. But yeah, so this is what I came up with, this USGS map. This shows like that we have 400 miles of coastline, which is definitely a lot for a state this small. I have this little zoom in of how we deal with coastal access in the state. So this is the Coastal Resources Management Council designated rights of way. And this is a map of a few of those. And so rights of way you can kind of think of as perpendicular access. If you know about coastal access issues, you probably know the difference, but for anyone who doesn't, rights of way is basically accessing the coast from like non-coastal spaces, right? And so I have this sign, which is one of our designated rights of way, and this is kind of how we do it in Rhode Island. We actually have an agency that designates these spaces, and then I have this little cartoon that shows all the different issues that pop up with these kinds of rights of way, these ways of accessing the coast. And then I have this kind of idyllic little pathway, which is like this wooden pathway, this little way to access the coast where, even if you needed a wheelchair or needed to push a carriage of some sort, you could get down to that water. But obviously it's not always so simple. And actually today, what I'm going to be talking about is what it means to access along the shore. So you've already gotten to the water, but you might want to go to a different part of the beach, different part of the water to surf or to pick up some seaweed. So how do you actually access along the coast? So we kind of call this parallel access as opposed to perpendicular access. So history of shoreline access in Rhode Island. This is Charles II, who was instrumental in handing down this Rhode Island Royal Charter, which did recognize some rights for hunting and fishing in the waters. So, pursuing whales and fishing fish. So that dates back all the way to 1663, where some of these rights were recognized for what you can do on the shoreline in Rhode Island, even before the United States, even before Rhode Island became a state. And so Rhode Island actually operated under that charter until 1842, when it passed this Constitution, which went into effect in 1843. And so this Constitution recognized privileges of the shore. But what did that mean? What could you actually do on the coast? This 1941 case, Jack Voney versus Powell, recognized that passage along the shore is one of these privileges of the shore. So that is something that's protected, is the ability to pass along the shore, right? Then we had this case, State versus Ibison, where the shoreline boundary was recognized as the mean high tide line by the state Supreme Court. Now, this is important because this was a criminal case, and so for criminal trespassing, at least, they were saying, like, you're trespassing at this boundary. But still, it didn't really clear up, like, what are you allowed to do, even if it's a space that's otherwise private, even if it's space that you might not be able to do some other things under the public trust doctrine. For example, in a lot of states, you can do things like fish or hunt. So carrying a gun or carrying a fishing rod actually protects you from any sort of trespassing liability. And so do we have that same sort of thing in Rhode Island? Well, under this criminal case, the public trust doctrine was not mentioned at all. So Rhode Island convened a constitutional convention in 1986. They actually thought about implementing, like trying to respond to that question directly, and they thought they did by kind of leaving the uses flexible, but they did codify the Jack Boney privileges that had been common law up to this point. So they actually left it flexible because they were worried if they did set it at one location, if they set the shore for all these uses or for certain uses at one place, then it might abrogate existing uses. So they didn't want to have like a one size fits all. So they thought they were basically leaving enough flexibility, but deciding the issue. So post this Ibison decision and post the Constitutional Convention, is the line where access is permitted at this mean high tide line, which the state court just kind of adopted this Borax standard, which is really just the line of the sovereign submerged lands that are given to the state upon statehood. So is this where access is permitted, or is this just merely a property line? So this was kind of left open, even though we were trying to get toward clarity. So 2019, Scott Keeley gets arrested. So this made a lot of news, and as the headlines say, seaweed collectors arrest revives age-old debate on Rhode Island beach access, centered on whether he was on public or private land. But once again, that's not really the issue. It's whether or not he was even on public or private land. Does he have the right to access that area for what he was doing, which he was gathering seaweed, as the headline suggests. And so this was once again thrust into the headlines, thrust into the spotlight, and legislators started trying to deal with this issue and give more clarity on it. So shoreline access law was passed in 2023, codified at Rhode Island general laws, and there had been these previous iterations that had thought about putting the location at the vegetation line or a 6 feet line, which the vegetation line had been considered by that constitutional convention, but they decided they didn't want to fix it in one place, as I mentioned. But this, once again, sought to define where beachgoers were allowed to be. Where on the beach can you know that you're not breaking the law, that the cops won't be called on you, that you won't have to watch your back while you're walking along the beach. So this does not transfer ownership, but it does ensure that the public's existing right is respected. So this is really tied into that public trust doctrine, which countries like Canada and Commonwealth countries, but also this really goes back to ancient Roman law. And so most countries and most civilizations do respect some sort of a right to the coast and to the ocean. And so this is really what this law was getting at, is saying, okay, well, we have this constitution, we had this royal charter. What are you allowed to do, and where are you allowed to do it? So this protected private property owners' rights as well, because it actually limited liability on that 10-foot strip, that 10-foot ribbon. So it said that, if people are walking along that area and they get injured, you're not liable for that. And then localities can regulate this like other public areas. So this was a big outcry, like, oh, we're going to have people on the beach at all hours of the night. No, you can regulate as a town, or using other laws to actually regulate when someone's allowed to be there, and when's reasonable, and what's reasonable to be done in those areas. So the legislation was based on the study commission's findings. A study commission had been convened after this was thrust into the spotlight. And so this really represents best available climate science and defensible legal approach and other deliberated trade-offs and compromises. So I have this little like kind of public-facing infographic on the side. Public access, you can be here. And so it shows this most recent visible seaweed line is where you're allowed to be. So if the police are called, or if you have a landowner that comes out to talk to you, you can point to the visible rack line, the visible seaweed line, the most recent one, and say, I know I'm allowed to be 10 feet within 10 feet of that. So it tried to give clarity to people using the coastal resources as well as the property owners as well. And there was, certain climate science and those sorts of things were taken into account. Let me go forward. So I did want to show the language. This is pretty specific, pretty in-depth language about where you're allowed to be on the coast. So yeah, I just kind of mentioned it, and I'll speed through this, but I did want to mention they did take into consideration probably a lot of questions that you as the audience are wondering about this. And I do apologize if you hear some background noise. They look like they were starting to bang outside. So if you hear something, that's what that is. So there have been several lawsuits, and these were expected. So the first one was a federal lawsuit, Rhode Island, RIACT versus Naranha, which was the Attorney General. This was a federal court case which was dismissed, and the court basically said you sued the wrong party in the wrong court. So then we had these two state court cases which were successful at the lower court, and there was not much legal analysis. The court just said this is an unlawful taking, which, as I've hopefully presented well today, it's not a physical taking. It would be, if anything, like a regulatory taking. It's this little area that you can use as an easement, similar to like a sidewalk is how I describe it. So the work of our project is we got a grant from the National Sea Grant Law Center to evaluate this new law's effectiveness in several ways. So I'm working with my colleague and collaborator Nate Vinhateiro on climate science research. So a lot of this was already done in that study commission, but we're really trying to highlight it and connect it to the law and to how the law can be successful currently and going forward. The legal research piece, researching whether this new definition of shore is sufficient, especially under climate change, so under eroding shorelines and rising seas, or whether some other standard is going to be more resilient. So yeah, we've done this work of getting to this place now, and then what's the future look like for Rhode Island, but also other states and other countries that want to address this sort of thing in the future. And then we're also convening focus groups, which will actually ask user groups, is Rhode Island's new shoreline access law actually increasing access to the shore? So there's always that distinction between like, yeah, I might have a legal right to do something, but is it actually happening? So we're going to work with fishers and surfers and other coastal resource users to answer that question. I think this coming summer, but that's still yet to come. So the legal definition piece, is this legal definition sufficient? So this is kind of a pretty like a cross section of these different areas. So the vegetation line that kind of shows like that's the end of this like kind of coastal area that has waves. And so states like Rhode Island have these boundaries that are called like the highest wash of the wave is what they call it in Hawaii. But the vegetation line is what other jurisdictions call it. So whether just the high water mark plus 10 feet is what we want, or is something else going to be responsive to climate change? The court, though, could just revert to the previous boundary, and they could do something else. This case is before the Rhode Island Supreme Court. That last successful opinion was, or those lawsuits were successful, but they left the law in place, importantly. So you can still access 10 feet above the shoreline here in Rhode Island, and the Supreme Court is hearing this case right now. We just filed an amicus brief, Surfrider Foundation and Backcountry Hunters and Anglers, and I worked with an attorney here in Rhode Island to file that. So how does this all fit within the expected sea level rise, erosion? These are things that like we're going to put all together when we finalize this research and when we talk to other like people in our focus groups. So takeaways on the future of shoreline access. So this 10-foot line, this was actually something that not many jurisdictions have tried, which is let's actually say what it means to pass along the shoreline, what the public trust doctrine requires, and things like that. So they were pretty sure they were going to be sued, and they have been sued. And this is kind of like, let's see what happens here. Let's see if they're successful. The legislature is confident because the Supreme Court has said that it is within the right of a state to define its laws, essentially. So trying to define shoreline at this place is hopefully legally defensible, and it's not a physical taking. So 10 feet might not be sufficient, so we're looking into that. This litigation is ongoing, so we'll hear from the Supreme Court maybe later this year, but maybe even into next year. Next steps are these focus groups, as well as putting all of this information together, looking at the legal sufficiency, especially kind of waiting on what the Supreme Court does, and trying to kind of answer these questions. So yeah, this was a plain banner that's been flown several times over the state. The Rhode Island shore is not private. This is a very contentious and important issue to the state of Rhode Island and to the country and to, I'm sure, everyone at this conference. So I'm excited to be here, and I'll take any questions.
Awesome. Thank you so much, Jesse, for your super awesome and interesting presentation. I didn't know about the law until your presentation today, so I even learned something new. So thank you for that. There is already a question in the chat if you want to cover that now. From Flavia, she mentioned it seems to be very common to use high tide lines as a mark for beach access or to define public spaces as a coastal area. I think she's asking, how is this solved at Rhode Island if, since the sea level is rising, the tide line will essentially change?
Yes, exactly. So this is exactly what they were trying to be responsive to when they passed this law. It says 10 feet above the most recent high tide. So yeah, this is the problem every day when you go to the beach, because the landowner is going to say, look, my heights, like when I bought this house, they told me, you know, I own up to this point. And then I've seen signs, which I use in the classes I teach, where there's like a sign in the water that says private property. It's like, no, that's the sovereign submerged lands that are owned by the state for all of us to use. So yeah, it's a contentious issue, and it gets more and more complicated as sea levels rise and the coast erode. So that's I've looked at this. I've had students and I've researched this issue, trying to look at what every state has done, and the court just says, of course, it's the high water mark, or in states like Massachusetts and Maine, it's the low water mark. They don't really give much of a reason behind why they chose that or how that's enforceable. This Borax decision had this 18.6-year average, but you would have to hire an engineering firm to go and decide where that line is for you. And then, of course, you would have other people coming and saying, no, we hired a different engineering firm and the line's over here. But no one has the money to do that from the coastal advocacy side anyway.
Jesse, I see another question in the chat, and it kind of connects to a question I had. So the question in the chat is, you mentioned backcountry hunters and anglers. Is there an intention to try to apply this approach legislation to non-coastal areas? And this idea of fishing and hunting that you mentioned is quite interesting, because it goes beyond just the movement along the coast, but actually the use of the coast when you're accessing it. So I guess my kind of question, kind of tacked on to this question in the chat, is, does the shoreline access law address uses of the shore when you're using those access points?
That's a great question, and they stayed away from that. The Constitutional Convention did recognize explicit uses, and the public trust doctrine originally protected these 3 triad uses, and then they expanded to other appurtenant, so like essentially like connected uses, so like swimming and things like that. But that's a great question. And as far as backcountry hunters and anglers, it's more about the coastal access piece for their involvement in this issue. So it's explicitly related to their advocacy for the shoreline access law when it was passed. But yeah, it does not set into stone coastal uses. But importantly, when the Constitutional Convention convened and they decided on this language, it said and other uses not enumerated. So they left open. The idea was to be flexible for uses. And within the last half century at least, recreation's been the biggest use that's been recognized in most jurisdictions. So saying you can recreate in these areas, and that is protected under the public trust doctrine, whereas that was traditionally only protecting things like fishing and navigation.
That's great. Thank you for that. And there's some more questions in the chat, so this is really great. So Hannah has asked, could you tell us more about some of the advocacy or community efforts to preserve access? I'm particularly intrigued by the plane banner. And I also had this question of what was the public discourse around the law at the time? Was there pushback? Was there advocacy efforts to get this over the finish line? Because even in Nova Scotia, I mentioned the Coastal Protection Act in my presentation early this morning, we're still not over the finish line with that, and it's been 8 years. So yeah.
Yeah, great question. So someone from backcountry hunters and anglers actually just spoke in my class on Monday and kind of talked about how there were a lot of, first of all, it was a very popular piece of legislation. It actually passed even the summer before when it didn't pass all the way. It was passed by one house unanimously. So it's very popular even within lawmakers, but it's a very, very important thing for Rhode Islanders. So yeah, you have the few people who are lucky enough to own coastal access or coastal properties, and then you have everyone else who wants to get to the ocean. So it's a very contentious issue. There's a Facebook group that's very famous here in Rhode Island that I'm sure you could find. I forget the name of it. It might be called Saving Rhode Island Coastal Access, something like that. And then there's a similar Instagram page that are very contentious, and people are always posting like plats, and we have really contentious arguments and legal arguments over legal controversies over the perpendicular access as well. Spring Ave being the most important down in Westerly, which is where Taylor Swift lives. And we say it's basically like Connecticut because they're so bad with their coastal access down there. But yeah, there's a lot of contentious issues. It's a very popular position to be in favor of coastal access because 400 miles of coastline, not many people are able to live on the coast. But yeah, it's something that there's a lot of advocacy for.
Great, thank you. Just one more question in the chat from Prem. Have there been cases where expanded shoreline access conflicted with protection of intertidal ecosystems, such as rack zones, nesting areas, or nursery habitats? And how were those conflicts addressed?
Yeah, that would be a question for my colleague Nate, but we do, like I mentioned, I showed that piece of the law, and that's really just like telling you what that line is. There's more in the law that does talk about things like that. I know the most contentious thing was coastal squeeze, really, and so built structures. So like if someone did put a seawall up and things like that, you don't have the right to go up on the seawall 10 feet above. But yeah, as far as conflicting intertidal and habitat zones, I am unaware of any, but yeah, my colleague Nate would have been able to answer that, who's also on this project. But yeah, that's not something I've been aware of. I know there's all sorts of issues with like piping plovers in certain places, conflicting, and there's always going to be an issue with conflicting uses. That's why I do want to say, like, yeah, this is all subject to reasonableness and to other restrictions. So yeah, I'll just leave it there.
Thank you. Yeah. And welcome maybe one or two more questions in the chat if folks have them. You posed some questions in your slide, so I thought I would just ask, like, what kind of your early observations so far, or what you're hearing. Has the new law increased public access?
Yeah, so it's been really and actually, it's funny. That same individual who spoke in my class on Monday has said that was part of his presentation. Like, oh yeah, we've heard great things, but also in this amicus brief, we wrote in the amicus brief, like, yes, backcountry hunters and anglers, like members have told us, Surfrider Foundation members in Rhode Island have told us. So yeah, that was part of our brief, was saying that this is working and this is giving more clarity to landowners and to people who want to access the coast. So we're hoping that it stays in place.
Great. I don't know. We have a couple more minutes here. Lily, I don't know if you have any more questions.
Yeah, thank you. I guess just like a question I have for you, just like in general, Jesse, what like first drew you to coastal access as a research focus? Was there a particular moment or case that like originally sparked your interest in the topic?
Sure. Yeah. I grew up, spent most of my life, grew up, whatever you want to call it, in Florida. And I went to law school just to work on this issue. I always wanted to work for the Surfrider Foundation, litigating these kinds of lawsuits and advocating for these kinds of things. So that drew me to law school. And then I got a master's of law. I was lucky enough to get subsequent positions in academic institutions where I get to do cool things like, come and talk about these issues and actually research them, as opposed to doing the litigating, although that's fun as well. And I have colleagues I work with on things like amicus briefs. So yeah, just love of the ocean and seeing that people, like, I went to the beach and I was told, oh, you're not allowed to come in here. And I read in surfing magazines actually about how important this issue was and how Surfrider Foundation is bringing all these lawsuits and doing all this advocacy to keep the coast open, because people are trying to close off and privatize the entire coastline.
Thank you. Yeah, we do have another question in the chat, and we have a couple more minutes. I think they're working on a technical issue on the back end for our next speaker. So the question here is there any aspect of the law that compels property owners, I'm assuming private property owners, but perhaps not, to remove structures inside the protected area or protected zone? So you mentioned this idea of creating structures, and then as you have the coastal squeeze, maybe you're not allowed on those areas.
Yeah, great question. Not this specific law, but there is already laws or regulations where if you were to put some sort of a protective structure, you do have to take coastal access into account for that already. So there's already a requirement that if you do have some sort of a protective structure, you have to actually design it so that coastal access is ensured, to the point where we have this one protective structure that looks like a drawbridge because there has to be coastal access allowed. So yeah, not in this law itself, and that's actually a problem with coastal squeeze and the need for things like retreat. But yeah, that's something that's hopefully already accounted for in other laws and regulations.
Mm-hmm. And we do. I mean, this is great. People are asking all kinds of great questions, and I hope you don't mind. So another question here, Jesse, can you talk a little bit about the issue of property disaster insurance and how that's impacting coastal change in Rhode Island?
Oh gosh, that's such a
that's a tough one.
Yeah, I spoke at the Senator Whitehouse's energy ocean thing a couple of years ago, and it was all about insurance, and people wanted to talk about that. But yeah, insurance definitely was huge when I lived in Florida, and then in Virginia, which is where I most recently was doing academic work. And I know, yeah, I mean, it's a big issue, National Flood Insurance Program, and trying to not incentivize people to rebuild in the same exact location and make the same mistakes, but really the law is reactive and really just actually incentivizes people typically to build within their same footprint. So that's a huge issue that could have its own symposium, and I'm sure it does, but I would just say that it's definitely a huge issue here in the United States, and it's, I remember there was work in Queensland, or so in Australia as well, that looked at this, but yeah, huge issue, and hopefully less incentives are being put into place for people to remain in precarious locations.
Yeah, this idea of grandfathering in structures and then not going outside of the existing footprint is a really big issue that we're seeing, or a concept we're seeing in Atlantic Canada too. And I mean, even in Prince Edward Island, I had mentioned in my presentation about this new development, and there was a small house, and then they were going to plan to create 5 new structures that was way outside the initial footprint. So yeah, it's definitely something that we're seeing, and then I know too here in Nova Scotia the issue of insurance. And also other risks to, for example, emergency responders. If you have a building that's built too close and suddenly something happens, what do you put first responders at risk to go save someone who is now in a building that's falling into the ocean? So, yeah, and that's part of this broader idea of, well, coastal access is not in, you can't envision it in a vacuum. It's part of coastal management, coastal stewardship, good bylaws, and land use planning. So, yeah, that's really great. I'm just checking in here. They're just doing a quick tech check, and then we'll be on to our next speaker here. And I see a question in the chat, another big one. But is there room for a constitutional challenge for protected access?
So is there room for a constitutional challenge for protected access? So that's actually, I think that does get to the heart of the law is essentially just saying what the law already said or what the Constitution was meant to say. And so, yeah, I guess there is room for a new constitutional amendment, and that's very challenging. The Constitutional Convention did convene and did come up with this new language. But yeah, it's very hard to make constitutional changes, but that's why they're actually so hopeful that this law will be kept into place, because all it did was define the shoreline and say like what this term means essentially, which is within the jurisdictional ambit of a legislature. So yeah, I would say that there is. I guess you could bring a lawsuit and say this constitutional provision should protect these things if that's what the question is asking. That could be an idea for a lawsuit, but I just think that the Constitutional Convention's materials that actually say, like, we could have done this, but we decided to leave it flexible, would make that really challenging.
I thought it was off mute there. Yeah, no, that's really great. Thank you for all of those responses. You got a ton of really tricky questions, and I know even the questions around the high water mark or the low water mark or some other boundary marker are questions that I don't think are going to away, because you're dealing with a dynamic environment where it's constantly shifting as a natural consequence of erosion and sedimentation and all the other things that are going on in that space. So I'm just checking in here to see if we're ready. I think that we are. So final round of applause for Jesse for the great presentation and taking the time to answer all of those questions.
Thank you for having me.